The Mad Hatter here with part 21 of the My Docket series on Corazon real estate. 3 more of these videos before I catch up. Again, sorry for falling behind, guys. With this document, or with this video, we're going into the answer to my amended complaint. So this is the first time Charles Chinichi hires an attorney. This is when they make their appearance. This is when they make their first few filings. Mindset, maybe a little nervous, but I really don't remember being nervous. I really don't. And that's probably not good. It's probably just a representation more so of my ignorance, just not knowing as much then as I know now. Because I do believe at the end, I mean, I have a few comments to make about the outcome of the case and why I think I might have ended up lucky with the outcome. But I'm not going to talk about that until I actually get to the end. But for now, I don't think that I was too troubled. I mean, I think that that was basically part of what I expected would occur even before the Supreme Court intervened. And so I don't imagine that my mindset was too dark or negative. Anyway, I think, guys, at this point, this video, just like many of the others in the series, we really are just going to need to get straight into what Corazon Real Estate has filed. Here we have Corazon Real Estate's answer to the amended complaint. Looks like they hired Thorndall, and Armstrong, Delk, Balkan, Bush, and Eisinger, and the attorney on the case is Katherine Parks. I remember her being a little too emotional. I remember she got some assistance later from a different attorney, probably at the same firm, a colleague of hers, and I remember feeling a little bit disrespected by this attorney. Not really so much that I can remember in detail why. I just remember having that vibe. And then I remember the other attorney who took over for her being more respectful. I remember feeling like that part of the litigation process, was not as frustrating as it was when I was dealing with this first attorney, Katherine Parks. But again, guys, it must not have been that bad because I can't remember specific details. Anyway, she's filing the answer and she's going to do affirmative defenses first? Doesn't sound right. I think that this is a typo. I don't think she meant to put this here. Let me scroll down very quickly to see what's going on, guys. Oh yeah, that's a typo. Okay, yeah, that's definitely a typo. Okay, this is not her first affirmative defense. She probably just meant to put like answer or something like that, because I can tell that it's not an affirmative defense because she's admitting and denying stuff, which is what an answer looks like, or at least the first section of the answer. So she's going into the allegations of the complaint. She has insufficient knowledge, so she denies them on that basis. She admits the allegation in paragraph 3. She admits the allegations in paragraphs 4, 6, 8, and 12. If you guys really want to, you can look and compare what's going on between my complaint, my amended complaint, and then this answer to amended complaint, so you can see precisely what it is that the attorney is admitting to and denying. But the gist of it is that, the facts of the case and the allegations made are in dispute. The things that she's admitting to are probably like the dwelling unit and who owned it and the business entity and me and that we entered. Like, there's a lot of basic stuff that's foundational that she's going to admit. And then the specific points that I allege that are relevant to punitive damages and all that stuff, that's all going to be disputed or denied. You're probably going to get a lot more out of this document if you compare these admissions and denials to the complaint, and if you watch the video, the complaint, and if you also watch the video, the answer. So it's going to be this video and those 2 other videos that are going to hopefully help you understand what's going on here. Second defense. So this is actually the first affirmative defense. It's just mistitled, and it's going to be, each of these are going to be a little off, but it doesn't matter. The point is, she's also making affirmative defenses. I do have a video on the topic affirmative defense, and these allegations are meant to nullify liability or damages. But the only difference between these and the other portions of this answer, is that these things actually have to be proven by the defendant. A lot of times people have heard that the plaintiff has to prove the case. That's mostly true. But when it comes to affirmative defenses that are raised by a defendant, those specific affirmative defenses actually have to be proven by the defendant, not me. So a very interesting little tidbit there. You're going to learn a lot more if you watch the video on the topic affirmative defenses. So let's see, failure to state a claim. I think she does file something. At all times and places, they're saying that my fault exceeds that of the defendant. I think this is called contributory negligence or something like that. I don't know. Then we've got occurrence referenced was caused by acts or omissions of a third person. Okay, so then they're saying that there's potentially other people who have caused the damages to occur, not them. Risks and dangers involved were open, obvious. Okay, so this is assumption of risk. I've heard of this before. I think that's what this is called, assumption of risk. So they're saying that I assumed the risk and it's my fault. Sixth affirmative defense. It was necessary for the defendant to employ the services of an attorney to defend the action. Reasonable sum should be allowed. This is odd that this is an affirmative defense, because they usually deal with this post-judgment. Maybe it's the same thing, but I doubt it. Attorney fees and costs in Nevada are a post-judgment issue. It's not really part of the case itself. After the case is closed, then usually somebody files a post-judgment motion for attorney fees and costs, and it's dealt with some other analysis. I've heard that they can get attorney fees as special damages, but I doubt that that's an affirmative defense too. The claim for attorney fees as special damages would probably be in a counterclaim, not an affirmative defense. So this seems weird to me, but again, I haven't done any research on it. Maybe they're right. Seventh affirmative defense. Plaintiff did not exercise ordinary care, caution, or prudence, and that the same was directly and proximately contributed by the negligence. So maybe this is contributory negligence. I don't know. Eighth affirmative defense. They're saying that I failed a timely plead. So this might be laches or the statute of limitations, or maybe both. Maybe both are lumped into this. Court lacks jurisdiction to consider the claim. Definitely not personal jurisdiction. Maybe subject matter jurisdiction. Maybe if the oppression isn't proven, then the court lacks jurisdiction. Maybe. See, I don't think so. I think that would be dealt with before in a motion to dismiss. I don't know. It just seems odd for that to be. I don't know. Maybe, guys. If you want to learn more about subject matter jurisdiction, watch my video on the topic subject matter jurisdiction. Defendant alleges at all times that the amended complaint, that I was not in privity to the contract. I feel like they just copy pasted this in here. I mean, obviously, I'm the tenant. If they're saying that I wasn't part of that contract, then this whole thing would fail, against them. I mean, why would they be able to claim any damages if there was no contract between us? I don't know. Maybe I feel like that's just kind of copy pasted in here, and they just didn't really care if it was relevant to the case or not. Accord and satisfaction. Okay, that's definitely an affirmative defense, and I might even have a separate video on this topic. Accord and satisfaction. Basically, this is used to say that there was like a deal we came to, or that they already paid me off, something like that. 13th affirmative defense, constrained from invoking equitable jurisdiction and an equitable remedy because I have not come before with clean hands. Yeah, so they have a doctrine called unclean hands. The gist of it is that the plaintiff did something wrong and they shouldn't be rewarded by the assistance of the court since they themselves did something that's wrongful. Basically, I mean, if you're doing things that are not, are illegal or wrongful, you can't come to the court and expect the court to help you. But, it's more complicated than that. It's kind of an oversimplification. And so unclean hands is a pretty big thing. Maybe someday I'll do a separate video on that. Failure to mitigate damages. Very common. Affirmative defense, I think very relevant in a lot of cases, maybe even all cases. Basically, that if you have been damaged, you have a duty to mitigate your damages. And if the other side can show that there's something that you did that was kind of like aloof or ambivalent towards the damage that you were, suffering, that you didn't actually try to minimize or mitigate the damages, that specific portion, that's on you, and that they don't have to pay that. I might talk about this in a separate video. There may be a video on the topic of duty to mitigate damages. The damages, if any, incurred are not attributable to any act, conduct. Basically, they're trying to say they're not liable. trying to say that maybe damages did occur, but that it's not their fault. Somebody else may have done it. That's what I'm imagining with that there. A sixth affirmative defense, plaintiff with full knowledge of all the facts connected with or relating to the transaction, ratified and confirmed in all respects the acts of the defendant. Basically, this one's trying to say that, if anything wrongful did occur, that I accepted that, or that I ratified it, or that I approved it, or that I in some way told them they could do it. 17th affirmative defense, Estoppel. There's all kinds of different estoppels that they could be trying to assert here. Collateral estoppel, equitable estoppel, promissory estoppel, judicial estoppel. If you want to learn more about those, there's videos on all those topics, I believe. I know I have one on judicial estoppel, and I know I have one on equitable estoppel. And the one on collateral estoppel is probably under the video issue preclusion. That's the other term for it. And plaintiff by his acts and conduct has waived and abandoned. So they're trying to say that I've expressly waived, or that there's something that I have done that to trigger waiver. I'm barred from recovering any special damages. I'm not asking for that. I don't think I'm asking for special damages. 12th affirmative defense. To the extent that I've been reimbursed, then I'm not asking for special damages. They're claiming that if I was reimbursed in some way, that would basically nullify the special damages. 21st affirmative defense, pursuant to Rule 11. Okay, so they're saying that they can add affirmative defenses later on as they discover them. A certificate of Rule 5 service indicating this document was mailed to me. Then we have a request for submission. I'm just submitting to the court the order of reversal. If you want to learn more about the request for submission, please watch my video on the topic, request for submission. Rule 5 certificate of service indicating I mailed this document to Katherine Parks. Notice the change of address. Very important document, guys. If you don't file this, they can send stuff to your old address and claim you've been served. And it works, so don't skip this. Watch my video on the topic, notice of change of address. And then Rule 5 certificate of service indicating this was also mailed to Katherine Parks. Affirmation indicating this document does not contain a social security number. Another request for submission. This one is submitting to the court the motion to require Corazon to pay the costs of filing to the court. Rule 5 certificate of service indicating this document was mailed to Katherine Parks. Going into the aftermath, I filed 3 documents, but they were free filings, so I incurred $0 in costs. The attorney for Corazon Real Estate filed an answer. That is definitely not a free filing. I'm going to check really quickly what the price is for that. Okay, so based on what I'm looking at, it looks like $208 is the filing fee, and I would assume that amount was either $208 at the time or maybe just a little bit under that, because these amounts do go up over time. But let's just assume $208. If the difference is there, it's a negligible difference, maybe 20 or 30 bucks. $208 in costs for the defendant. I didn't have an attorney, so I incurred $0 in attorney fees. The attorney would have probably reviewed my the 3 filings, negligible really, the 3 filings that I made, but their answer is not negligible. They would charge something for that answer, and I don't think it would be a whole lot. Like, it's probably not 3 or 4 hours, but it's probably around 2 hours, maybe 3. I'm going to err on the side of 2 hours because, I mean, there's some crazy answers out there prepared by attorneys that are 10, 20, 30 pages long. This answer was not that long. I really feel like it's fair to say 2 hours for that, because there was probably a meeting with Charles Chinichi, and there was probably some back and forth, some emails, some phone calls, getting the details. There's probably a little bit behind that answer. So I think 2 hours is reasonable. At the rate of $250 an hour, that's going to come to $500 in attorney fees for the defendant. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.